You can get a certificate of occupancy here by going to the New York Department of Buildings, or you can simply go to Google and type in New York Department of Buildings. Go to their website. So now that you've researched your case, you have a sizable file folder which you can bring whenever you discuss your case at a community organization, a tenant clinic, or an attorney's office. That folder will contain your lease, DHCR rent history, certificate of occupancy, your deed, HPD violations printout, and multiple dwelling registration. Now that you have your documents, it's time to look at the resources in your community. Now that you've worked up a file on your building and researched your landlord, we're going to talk about the possible methods of fighting your housing court case. Now in this video, you're going to pick up the remote and make a choice. There are two types of housing court case, the non-payment and the holdover. A non-payment case is a case where the landlord is suing the tenant for rent. A holdover is generally any other type of case besides a non-payment. These two types of cases are very different and different methods apply. So pick up your remote, select which type of eviction case you're fighting, whether it is a non-payment or a holdover, and we'll continue with this video. to focus on how to fight your non-payment case. There are 3 things that you need to know about your landlord's suit for the rent. First, this is the most common form of housing court case. Second, most non-payment cases are settled. Third, most tenants in non-payment cases don't have an attorney. An attorney is always a good idea, but if you can't get one, you can and should talk to at least 2 attorneys before you do anything on your case. And by using the resources I give you, you can accomplish this without paying anything. You get one shot at this, so get as much advice as you can. You can't get prepared simply by watching this video. Whether you have a lawyer or whether you have to be your own attorney, let me give you the basics you need to know. The first paper you get is this one, the 3-day notice. It demands that you pay the rent or the landlord will begin summary proceedings to get you out. Remember how I talked about when you do this for the first time, you don't know what's around the corner? Well, this is a good example. Summary proceeding, what does that mean? Tenants think that's fancy language for changing the locks. Or people think that summary proceeding is like summary execution, that at the end of the 3 days they can get evicted. But since you saw the intro, you know that summary proceeding is just the name for a housing court proceeding. So what happens after those 3 days? Well, you will receive what's known as a notice of petition and petition. Take that notice of petition and petition and do your research, seek advice to put together your defenses, and then go down to the clerk's office to file your answer. And when you file your answer, the clerk will schedule you for your first court appearance, at which time it is very likely that you will negotiate the stipulation of settlement settling your case. In further court appearances, you may have to make a motion known as an order to show cause for more time. These are the very likely stages to take place in a non-payment case, and we're going to go over all of them in the balance of this video. Now that you can see a few moves ahead, let's get back to that 3-day notice, because it's a very important document. It's worth it to look at that 3-day notice in depth. The purpose of the 3-day notice is to give you the precise amount of rent you would have to pay in order to avoid going to court with your landlord. If the notice is unclear to the extent that it fails this basic purpose, the eviction case could be dismissed. So the first thing you notice about the 3-day notice is, does it state the correct amount of rent due? The eviction case will be dismissed unless the notice states an amount that is within the ballpark of what is actually due, and breaks down the amount to specific months. Take for instance that you live in an apartment where you pay $1,000 a month, except you didn't pay $1,000 a month for 4 months. Obviously, you would owe $4,000. Well, let's make this a little more complicated. What if you are in a dispute with your landlord, and instead of paying the full $1,000 a month, you paid half of the rent? So at the end of 4 months, obviously, you do not owe $4,000, you owe $2,000. As a result, the landlord in April sends you a 3-day notice and accurately demands $2,000. But in his breakdown, he claims that the $2,000 reflects the entire March and April